Yes, yes.
I beg to mention regarding item number 15 of today's list. I am
Here to deliver is too. Item number 15, yes.
I am seeking accommodation only for today, Lordship. Tomorrow, day after tomorrow, this week, any date, Lordship may fix it. A record has come, I will go through it.
Okay.
Thursday, man.
Huh?
Thursday, man.
So some pine. No, not possible. Not on Thursday. Learned Counsel Mr. A. Ahmed has prayed for adjournment. List this matter on Friday.
Obliged.
May I please, Your Lordship? I beg to mention item number 17, madam. 17,
17.
madam.
Okay.
Same prayer, madam. Can it be on next week, madam? Any date?
Next week, date. Learned Counsel Mr. D. Bora has prayed for adjournment. List this matter on.
Obliged, madam. 26.
Yeah, please, Lordship. I beg to mention this item for listing, Your Lordship. Matter
What listing?
listing, yeah, for orders, Your Lordship. Criminal
For
law, Lordship.
No, you have to mention before court number 8.
May I please, Your Lordship? I beg to mention item 28, Lordship.
Hmm?
28, item 28.
Hmm.
Lordship, perhaps CD not received, Lordship. Perhaps CD not received, Lordship.
Yes, I know this is, man.
Petitioner is the interim, Lordship.
Learned Counsel Mr.
B. Islam, Lordship.
B. Islam has prayed for adjournment. CD as called for is not received. Issue reminder number dated. Interim order shall remain in force till.
Much obliged.
Lordship. Lordship, with the concept from the other side, I'd like to mention item number 12 and 13 of the daily list, Lordship. Lordship, Senior Counsel Mr. S. Bosto, who was supposed to appear in this matter, due to some personal difficulty, he couldn't come here today, Your Lordship.
All
It
right.
may be adjourned for a day, Your Lordship.
Learned Counsel Mr.
P. Khatonier.
P. Khatania has paid for adjournment as the leading counsel. Could not attend court today due to personal difficulties. List this matter on. Permission has been obtained from. Permission has been obtained from the other side. List this matter. CBI process.
Lordship, and we were supposed to file our affidavit in reply. Lordship, we will
Permission has
file.
been obtained from Standing Counsel CBI.
Lordship, we will supposed.
Miss M. Kumar.
We were supposed to file our affidavit in reply, but today, during the course of the
List
day,
this
we will
matter
file.
after 2 weeks.
Obliged.
The Learned Counsel affidavit reply in this
We
case.
will file it during the course of the day today itself.
Okay.
Lordship, I'd like to mention listing of the anticipatory bail application, Lordship, for tomorrow.
Less than 7 years or more than 7 years?
Up to 7 years, Lordship.
Up to 7 years. When do you want?
For tomorrow, Lordship.
AB? For
Yes.
tomorrow? No way.
Then.
Wednesday.
May I please, Your Lordship, I'd like to mention item number 22 for adjournment for the day, Lordship. As my senior has some personal difficulties.
Learned Counsel Miss
J. Das, on behalf of S. Sur.
J. Das on behalf of Learned Counsel Mr. S. Sur has prayed for adjournment. You are on interim pay. List this matter on. Now, one second.
List after 2 weeks, Lordship.
2 weeks DTR teacher. 2 weeks of data DTR.
Item number 1.
May I please? Regular bail application, Your Lordship, under POCSO Act. No case is registered under section 6.
We'll have to issue notice.
Yes. And record may be called. Scan copy of the record.
Learned Counsel Mr. N. Upadhyay is present for the petitioner. Learned Additional PP Mr. R.J. Bora is present for the respondent state. Issue notice to the respondent number 2 returnable on dated DDR. Meanwhile, call for the scan copies of the
Dosti service may be granted.
Huh?
Dosti service.
Dosti service
Dosti
criminal is
service,
not
no.
allowed, my lord.
You will have to issue notice to the respondent number
Then
2 through the
by
history of this court routed
street
through
post.
the PP's office. You will have to issue in this manner. Through the history of this court routed through the PP's office. Notice. Meanwhile, call for the scan copies of the trial court record along with the scan copies of the CD. List on 3rd June.
Item 2.
Yes, your lordship. POCSO matter, lordship, is notice of issue.
Issue notice to the respondent number 2 returnable on
Just it.
that
That case, but skin.
scan copies of the trial court records along with the scan copies of the CD. List on 4th of June.
Item 3. Please, Your Lordship. It is case, Your Lordship, 439, Your Lordship. Regular bail, so FIR and PROCEED are there. Monday, Your Lordship, from Dhula, wrong, Your Lordship.
CD?
Both the CD may be called for, Your Lordship.
My lord, Monday, my lord,
25,
next Monday.
Your Lordship. 25, Your Lordship. Both the CD may be called for. Dhula PS case number 38 and 39 of 26. There is PROCEED is there. Our FIR is 38. Page 10 is the FIR and 16 is the cross FIR. We have lost half
Call for the CD.
of Dhula PS case number 38 and 39.
Where is Dula? How far is Dula?
Dhula PS here, the wrong years. Dhula PS,
No, no, Dhola no, Dula.
Dhula,
Dorong.
Dorong district.
Okay. Call for the CD of Dhula PS case number 39 of 2026 and
38 of 2000.
Dhula PS case number 38 of 2026. List the matter on
20.
item 4.
Yes.
This is a regular bail application.
Hmm.
The petitioner arrested on 13/4/2026. The city may be called for from Sangsari.
CD along with the CD along with the medical report, my lord.
Yes.
What is 329?
Malad?
329?
Yes, 329 is there. 329 is criminal trespass.
Wow.
And the 118 is the grievous hurt. In fact, there is no grievous hurt. Let the medical
Call for the CD on
125 Sangsari.
call for the CD on along with the call for the CD along with the medical legal report of the
26, my
victim
lord.
on 26.
Yes. Eid is there, so 25.
Okay, 25.
Item 5.
May I please your lordship? Regular bail application, arrested on 22/4/2026. Here, my lord, I am pressing the bail application for non-compliance of section 36, my lord, which I have annexed at my annexure 3, page 26, which is a statutory provision, lordship, that has not been complied with.
We'll need the CD.
CD.
I have annexed that, my lord, at page number 26. And furthermore, my lord, if your lordship goes to the, my lord, affair also, I can satisfy your lordship that, my lord, no CD is required in this case.
Where is the FI?
My lord. Lordship will find that page 19.
Okay.
Dispute between, my lord, husband and wife.
Okay.
They had, my lord, in the year 2022/9/2017.
498.
No, my lord. Here, my lord, mostly allegation is there, my lord, that scheduled caste, scheduled tribe, Prevention of Atrocities Act.
There is Sessions Tribal case.
So, lordship, will kindly look at that, my lord. At page 19, lordship will find. Laws by the, my lord, wife. May I just read it, my lord? I, Srimati so and so, resident of so and so, respectfully submit the following for your kind consideration and necessary legal action. That during my college days, I came into contact with the accused, so and so, and we developed a relationship which later resulted in marriage in 2017. I am always lordship.
Item 6.
This is regular bail application. Charges POCSO is there, your lordship. So notice.
Okay, learned counsel Mr. K. Mira
K.
is
Mira.
present for the petitioner and learned additional PP Mr. R.J. Bowen is present for the respondent state. petitioner to take steps to issue notice to respond number 2, returnable on. Meanwhile, call for the CD.
City.
Investigation is going on.
Going.
Meanwhile, call for the CD, release the matter on.
Oblige.
Item 7.
Your Lordship, this is 483 bail application. The FIR is in page number 16. May I read the FIR, Your Lordship?
Read, yes, can read.
16, Your Lordship.
He was arrested on 6/5.
Yes, Your Lordship.
Theft case, cattle preservation. Page number 16. Please read.
Sir, this is to inform you that today on 6/5/2026, while I along with LNK Pankaj Gayan, LNK Pankaj Diori and driver Sahil Ahmed were conducting night patrolling under Khatawal PS jurisdiction at about 2:45 a.m. While we were moving from Penai side towards Samaguri side, one suspected vehicle was coming from Samaguri side towards Penai side. On suspicion, we asked to stop the said vehicle, but the vehicle tried to flee from the spot on seeing the police party. Then we chased the said vehicle wearing registration number AS8322, white color Swift Desire vehicle, and we were able to intercept the said vehicle at Geramuk. With the help of local public of that area came out of their houses, hearing the noise. As soon as we are able to stop the vehicle, one suspected person, namely Abirur Islam, son of so-and-so, village so-and-so, police station, Samaguri district, Nagaon, Assam, who was in the vehicle, managed to run away from the spot by taking advantage of darkness. On the other hand, another 2 accused persons, namely Rahmat Ali, son of so-and-so, village number 1, Khalihamari, and accused number 2, Ashikul Islam, son of so-and-so, village Sonari Bali, both are of police station Samaguri, district Nagaon. Assam were apprehended with the help of local public. Then the stop vehicle was searched and found.
Okay, in the dicky of the Swift Desire.
My lord, 3 numbers of cattle, my lord. Can it be possible, my lord?
I don't know.
I also do not know, my lord, how they have kept 3 cattle, my lord, in the diggy, my lord. Let the case diary be called for, my lord.
Your Lordship, the CD will be called for.
Call for the case diary, release the matter on.
Your Lordship, would it be possible if the matter is within this month?
To 29 months.
29.
Congratulations.
Item 8.
Maybe also. But if there is a 2 FIR, FIR and cross FIR, what you kindly come to page number 10. This is the FIR for which I am before your lordship.
9 accused person.
Yes, lordship, all are the same family, out of same family, lordship. Kindly see, lordship. Lordship, page 11, may I read, lordship, thus. May I read, lordship. Lordship, the
How many days you are behind bars?
no, lordship, this is pre-arrest.
Anticipated.
Yes,
bail,
lordship.
okay.
Our lordship, the affair, our affair, lordship, page 17. There is a cross affair, lordship, and in fact, the accused number, the petition number 4, he, lordship, he sustained grievous injury. I have another medical report, his medical documents, lordship. Page 24, 25, lordship. He was taken to Metro Hospital, Gauhati, lordship, where his surgery was done, lordship.
He was, okay, where is your FIR?
Yes, Lordship, page 17.
Page 1717.
Yes, Lordship.
Yes.
Yes. Page 18 is the offer declaration.
Mm.
Okay, this is the actual fact. Page 18.
No, Manwar Hussain sustained grievous injuries.
Yes, Lordship, Anwar Hussain.
Where is his medical report?
Yes, Lordship, page 24 and 25. His medical documentation. He was taken to Metro Hospital, Lordship.
Okay, yes.
Well, case there may be call for my lord, although my lord, the allegation made in the FIR, my lord, it is attracts my lord section 109, my lord, that is my lord, attempt to murder, my lord, and 118 grievous hurt, my lord. And their FIR, my lord, in which case, my lord, they are challenging, claiming, my lord, break for bail, my lord, that is registered first, my lord. That was registered at 39 of 2026, my lord. And their cross FIR, my lord, it is registered as, my lord,
In the month of April.
case number 50 of
Lordship, I have
in the month of
accepted
April.
that because
So at this stage, my lord, let the city may be called
Lord,
for.
due
Let
to
us
the
call for the
Lordship-
CD along with the medical legal report.
Lordship, kindly see, Lordship, he
We'll call
sustained.
for the CD along with the
Other
medical
two
legal.
ladies also in the petition of Lordship. And Lordship, only the ladies may be
No, my
considered.
lord, all the matter may be fixed together, my lord.
You will get the statements of the witnesses. Call for the CD along with a medical legal report. List of the victims, list the matter on short date or due by on 28th of May,
My lord,
Lordship, on 29, Lordship.
29.
29.
Yes, Lordship, your Lordship may call for both the case days. It will be Lordship.
Call for a CD of
Mankasa 39 and 50, my lord.
Suksar PS case number
Yes.
39 of 2026 and the CD of
Mankasa.
Suksar PS case
No,
number.
Lordship, it is Mankasa, Lordship. Mankasa case.
But here it is written as Suksar.
My focus is corrected, Lordship.
To the Mankasa PS case number 13 of 2026 and a CD of the this will be
28.
what?
Mankasa 50, Lordship.
Mankasa PS case number
50, my lord, 50.
50 of 2026.
Yeah. Of the
May I please?
Mm.
My lord, I am seeking transit clearance bail, but the petitioner is minor, my lord. So, my
Oh,
lord,
yes.
6 time may be given, I will appear before the appropriate forum, my lord.
Only for my lord, limited period, my lord, so that my lord, he
We
can
did not
travel.
get any.
No, my lord, regarding minor, I have not,
Okay, that division bench
my
judgment,
lord, I have
which paragraph?
paragraph 6, 8, 10, 11, 12, and 13. My lord, entire judgment is relevant.
Paragraph 6.
6, 8, my lord, I have,
Oh, you have noted it down?
my lord, in the below, my lord.
Okay.
Some place.
Heard Mr. A. Paramanik, na?
My lord,
Learned counsel for the petitioner Ilyas Alina,
my lord.
who has filed this application. Ilyas Alina
Illusory.
for the petitioner X, who has filed this application under section 482 of the BNWS 2023 with a limited prayer for transit anticipatory bail to enable him to appear before the Thana Cantonment, Dehradun Cyber Thana Cantonment, THAN, Thana CNTT, Dehradun, Cyber PS case number 140. Cyber Police Station, na?
Mal.
Case number na lage. Cyber Police Station in connection with so-and-so PS case under so-and-so sections. It is submitted on behalf of the petitioner that the petitioner X is willing to appear before the investigating authority, investigating a concerned investigating officer and cooperate with the investigation. Had Mr. Ajay Boro, learned additional PP Assam, had considered the submissions at the bar with circumspection. It is submitted that the petitioner, it is submitted the petitioner has relied on a decision of this court in connection with Dasharat Ray alias Deepjyoti Roy versus the state of Assam. In connection with AB 3286 of 2023, wherein by the order dated 29/7/2024, it has been held that para 6, 8, 10, 11, 12 or 13. To Mazat 9 to 9 start Bahariba. So we need not call for the case diary.
My lord.
We'll pass a order.
My lord, only my lord
Fine.
for a limited period, my lord, so that he can travel, my lord,
Yes.
and he can approach the my lord jurisdiction in court, my lord, only for this purpose.
15 days?
21 days, my lord.
20 days, okay.
It will go on the 4 days, right?
I have relied on the decision of this court in connection with Desra Trai alias Deepjyoti Roy Supra, considering all the entire aspect of the matter, the petitioner is allowed. Petitioner is directed to appear before the
Jurisdictional court, my lord. IU or IU.
IO within 20 days from today and cooperate with the investigation in connection with the aforementioned case, post up thereafter.
My lord, that may not be required, my lord, only for the purpose of traveling, my lord.
Okay.
As soon as my lord, he reaches the my lord, judicial court, my lord, he will approach, he will file necessary observation, my lord.
Okay, you know,
So necessary bail application.
bail application,
My lord.
not
That, my lord,
required to,
that, my lord, cooperation is not required, my lord.
or cooperate na lage.
Cooperation is not required.
And that bail amount and bail
No,
bond
that will not be required, my lord.
not be required.
My lord.
Yeah, according to that Hindu,
Only transit bail, my lord,
Yeah.
so that he can approach the my lord,
Yeah.
trial court.
according to that Hindu Korea case or what? Hindu,
Yeah, Indoria, my lord.
Yeah, Indonesia.
Korea Indoria's
Yeah.
case.
Para 9 of my petition, my lord, I have cited the Indira versus State of Karnataka and
Because
others. 2020.
there it is given that it's not required to
Other coordinated
give
branches,
interim bail,
My lord.
should dispose of at a stress.
My lord.
You have the order
my lord. Coordinated
Yeah,
branches order, my lord.
on
No,
Kia Injuria that has been cited?
My lord. Yes, sir.
Okay, that will be helpful. Which paragraph?
Para 8, my lord. Para 8.
But the sureties have been given.
My
in
lord.
Para 10.
Given in para.
That this my lord, transit bail will be my lord absolute bail, my lord. Because my lord, this will not be interim, my lord, because while
You
you,
are giving absolute bail, but without sureties?
my lord, then lordship may kindly impose, my lord.
Sureties is given in this case.
My lord, shield is given.
Paragraph 10, sureties is given.
My lord.
Yes, my lord. My lord, that may be imposed, my lord.
Can be included, no?
My lord.
Para 10 to লিখি দিবা 20 ডে para 10 to মানে নিচিনাকে লিখি দিবা একেবাৰে পিআই ইনটুয়ে নালাগে para নালাগে আৰু হেৰি okay, then will RJ Borua লিখিলা ন has accepted notice to লিখি দিবা on behalf of the respondent state. That much will include it
My lord.
because notice is also important.
My lord.
Paragraph 10 to নিচিনাকে লিখি দিবা
Highly.
মই চেক কৰি দিম প্ৰিয়া ইন্ডিয়া জাজমেন্ট লাগি তাত ভৰাই দিম দিয়া 8 paragraph 8 to pilot ভৰাই দিম পাছত yes
Highly.
so 21 days no 20 days 20 days 20 days item 9 for admission
Later, but in this case, conducting counsel is within another court, my lord. Password for time being.
I'm for the respondent number 2. I have to submit reply, your lordship. 3 weeks time we can allow your lordship.
Learned counsel Mr. AAR Karim has prayed for time to submit reply affidavit in reply
Lordship.
affidavit in reply
Objection, your lordship.
Time to submit his objection. List this matter after 2 weeks,
3 weeks.
3 weeks.
It will kindly be fixed, my lord.
Okay,
Matter
date at a reduction 3 weeks, sir. 17 June.
Oblige.
Oblige.
Item 10.
May I please, your lordship? Lordship, this revision is from the judgment of the trial court,
Just let
lordship.
me ask, if you are prepared, if you want to submit, any party is required the LCR? No, you do not require the
It
LCR.
will not be required, lordship, because what I am submitting, lordship, I think he will not be required to submit also. This is NIA case, lordship. And it ought to have been compromised because, and we have, court has given us time also, but he did not comply with that to pay 20%. And thereafter, but he did not comply with that, so Mayor, I'm not on that. Now, only thing is that, lordship, the check amount was double, lordship. Check amount was double. And moreover, because I have nothing to submit, because he did not adduce any evidence before the trial court to prove his defense, lordship. In the appellate court and the trial court, both appellate court affirmed the sentence of the conviction and sentence of the
That
trial.
accused did not adduce evidence.
He don't adduce evidence, lordship.
You are the complainant.
No,
I am the
I am the accused, lordship. Lordship, the reason cited for giving double the amount, lordship, only on that I am just submitting, lordship. If lordship comes to page 38, lordship.
Page?
Page 38, Lordship. The sentence part, Lordship. I have heard both the parties on the point of sentence. Leniency was pleaded for and on behalf of the convicted accused, whereas complainant sought for appropriate compensation as per law. Statement of the convict on the quantum of the sentence was recorded on a separate sheet of paper, and the same was tagged with the case record. I have duly considered the quantum of the sentence to be imposed upon him. I am also cognizant of the fact that nearly 6 years have passed since the issuance of the check to the complainant. This period has been has seen sharp inflation. Moreover, the check amount would have definitely yielded decent returns to the complainant if invested properly. The accused also caused significant delay in the proceeding of the instant case through his conduct. As such, considering overall facts and circumstances of the case, keeping in view of the nature of the offense committed, the convicted accused Sri Niranjan Sharma is sentenced to undergo simple imprisonment for 8 months and to pay a fine of rupees 16 lakhs. The check amount was 8 lakhs, Lordship, so it was double the amount.
You want the amount to be reduced?
Yes.
Lordship, there is a concurrent finding of both the courts below. And also, Lordship, they have admitted their guilt in the petition. In the revision petition, they say it's a security check. In the subsequent paragraphs, they are saying it is not a security check. But we
No,
will
but
not-
he's not disputing on any of this.
And
He
nearly
wants the
now-
amount to be reduced.
Now nearly around
I think then he
7
can-
years have lapsed. If they're admitting the guilt, there was a provision under the NIA to compound the matter when the notices were issued. That time they did not compound. They contested. And after we have gone through 2 rounds of litigation, now when award is granted in our favor, they want reduced sentence. On what ground they want reduced sentence, that is also not said here. Amicable settlement after 2 rounds of litigation, this is the 3rd round. On what ground should the reward be reduced? While availing the services of the complainant, they took dumpers. They took dumpers from the complainant. They utilized the dumper services. And now after 8-9 years, they want the amount to be reduced. If they wanted the amount to be reduced, they should have earlier gone for compounding. They very well
You
knew
see,
that.
it can be compounded at this stage also.
They
Because
very well
we fix NIA cases in the local alert. Can be compounded at this stage also, if you're willing to compound.
No, Lordship, we are not willing to compound the matter.
Lordship, I'll leave it to your Lordship to whatever Lordship order will be passed, because he has not complied with the order of this court. So I cannot go beyond that. That he has not paid that 20% of the amount. There was a direction to pay, Lordship. I'll leave it to your Lordship. Lordship will.
In their revision petition also, they are giving contradicting statements. First, they are saying that it was security check. In subsequent grounds, they are saying, no, we were not able to pay. Then they are saying we'll pay in installments.
The check was issued in the year 2018.
No, Lord, the 18.
17.
17. And the case was filed in 18.
When 2026 is going on. On what basis the amount should be reduced?
It was dishonored on 31/2018, Lordship. As per the trial courts.
And was drawn on 25/1/2018.
Okay, sit down, I'll dictate the order. Mr. M. Ahmed,
Yes, Lordship.
learned counsel for the petitioner Niranjan Sharma,
Niranjan Sharma.
alias Niranjan Sharma, alias Niranjan Sharma, wife, okay.
The name,
Niranjan Sharma, alias Niranjan Sharma, and Miss
P. Gupta.
P. Gupta, learned counsel for respondent number 2, and Mr. K. Bishop, learned additional PP for the respondent state. You went for appeal.
yes, Lordship.
Where is the appellate court's order?
Appellate court order.
Okay, I got it.
Yes, Lordship. From page 41, Lordship.
The petitioner has referred this revision petition under section 438/442 of the Bharatiya Nagarik Suraksha Samhita, B and within bracket B and WS for short bracket close, with prayer to set aside the interim judgment and order dated 27/6/2025 passed by the learned Court of Sessions. Passed by the learned Court of Sessions Judge Kamrup Metro in criminal appeal number 23/2024, affirming the judgment and order dated 13/2/2024 passed by the learned judicial magistrate first class in CR case number 1950 of 2018. Full stop. The petitioner was convicted under section 138 of the Negotiable Instruments Act 1881 within bracket the NI Act for short bracket close, and sentenced to undergo simple imprisonment for a period of 8 months and to pay a fine of ₹16 lakhs to the complainant with default stipulation, by the order dated 13/2/2024 in connection with CR case number 1950/2018. The respondent is Mr. Navajyoti Kakoti, who was the complainant who brought up the complaint case number 1950 of 2018. Against the petitioner. Full stop. It is submitted that the complainant stroke respondent number 2 is a businessman and a registered owner of 10 six-wheeler dumpers, whereas the petitioner is the proprietor of MS/NS Construction, MS/M/S, and Stop Construction situated construction company at Mongoldoy town, full stop. During the course of business, the petitioner took a dumper from the complainant on rental basis on 16/11/2017. In presence of 2 witnesses, Sri N. Ghosh and Mohatab Ali, full stop. First of the petitioner is sure to pay an amount of rupees 8 lakhs to the respondent number 2, and accordingly he issued a check of rupees 8 lakhs to the respondent number 2 bearing check number 0566 dated 25/1/2018, drawn on the Axis Bank, Mongoldoy. Full stop. It is content next page. It is contended that when the respondent number 2 deposited the check in his State Bank account at Dharapur Sariali branch, the check was dishonored with remarks within inverted commas, drawers apostrophe s, signature differs, inverted commas close. The fact of dishonor of the check was intimated to the respondent number 2 by his bank through a return memo dated 30/01/2018. A demand notice was sent to the petitioner through his advocate on 6/2/2018 through registered post to pay the amount within 15 days. The notice was served on the petitioner on 12/2/2018, but the petitioner failed to pay the check amount of rupees 8 lakhs, and hence this case was filed. To substantiate his stance, the respondent number 2, next, examined 2 witnesses. Only one witness. Adduced his evidence. One witness only?
Two
witnesses, okay. Adduced the evidence of 2 witnesses, including himself. But the petitioner subsequently failed to adduce any evidence in rebuttal. The respondent number 2, as PW1, exhibited 4 documents which includes check number 56668 dated 25/1/2018 hyphen which are as follows, which includes which are as follows. colon dash line check number 056668 dated 25/1/2018 hyphen exhibit 1, next line. Return memo dated 30/01/2018 hyphen exhibit 2, next line. Legal notice hyphen exhibit 3. Postal receipt of the demand notice. In next line, postal receipt of the demand notice hyphen exhibit 4. The other witness examined by the respondent number 2 was Sri Milan Ghosh, who deposed as PW2 full stop. The entire evidence, as this is a revision petition, the entire evidence is not required to be, the nitty-gritties of the evidence is not required to be dealt with in its entirety. This court has to find out if the concurrent orders of the trial court as well as the order of the appellate court suffers from any perversity or impropriety, full stop. It was held by both the trial court as well as the appellate court that the evidence of PW1 specifically established that there was no existence of any legally why if there is no legally enforceable debt, then where will this be a case of 138 of the NI Act? It was there was no existence of any legally enforceable debt.
They have written also.
It has to be a legally enforceable debt, but it was observed by the appellate court.
Which page number?
Page 5 of the appellate court's order. It will be at page 45, para 7. There was no existence of any legally enforceable debt or liability payable by the appellant.
That is one of the ground taken is that the evidence of PW1 is specifically established that there is.
This is not ground, no? Oh, one of the ground taken.
One of the
okay.
ground.
Edu nalage. এই লাস্ট লাইনটো কি লিখিছিলা তুমি সেইটো নালাগে কাটি দিয়া one of the ground taken okay এইটো লাস্ট লাইনটো কি লিখিছিলা কৈ দিছিল লাইনটো bus would show that the evidence of PW1 through his evidence on affidavit depicted revealed through his evidence on affidavit revealed that an offense under section 138 of the NI Act was made out against the petitioner who was thoroughly cross-examined by the who was thoroughly the petitioner full stop. The PW1 was thoroughly cross-examined by the defense with regard to the ownership of the respondent number 2 of any business of his business dealing with vehicles full stop. PW1 admitted that he did not submit any document to show to substantiate that he is the owner of 10 dumpers and he entered into any agreement with the petitioner on 16/11/2017. He also admitted that he did not specifically mention about the monthly rent or the duration, for which the dumper was given on rent to the petitioner. However, it has been held by both the trial court as the appellate court that from the order dated 7/2/2020, the petitioner admitted Exhibit 1 to be the check issued by him. And he also admitted Exhibit 1, and he had also proved Exhibit 1 within bracket Roman 1 bracket close as his signature. He also, the petitioner also admitted that he had issued a blank security check to the complainant for the purpose of a dumper vehicle, but the said transactions failed to materialize. Full stop. It was held by the both the concurrent. It was held by the just a moment. Trial court as well as the appellate court that during his examination under section 313 of the Code of Criminal Procedure within bracket CRPC for short bracket close, the petitioner denied no, huh? Both the trial court no appellate court लिखी दिया. appellate court, both the trial court and the appellate court now. It was held by the learned appellate court that even in statement under section 313A, the petitioner admitted that the check was issued by him to the complainant, albeit for ALBEIT on good faith for a different purpose, that is road construction, which he failed to materialize. But the complainant stroke respondent number 2 never returned the check to him. It was held by the learned trial court as well as by the appellate court that the petitioner failed to rebut the presumption under section 139 of the NI Act despite his plea that the check was not issued. Despite his plea that there was no legally enforceable debt and the check was not issued to repay the amount of rupees 8 lakhs owned by the petitioner to the respondent number 2. Full stop. The petitioner tried to agitate, during trial, the petitioner tried to agitate that the demand notice was not received by him, but it has been correctly held by the learned trial court that the petitioner had received the demand notice issued by the respondent number 2. It was observed by the learned through an elaborate discussion. It was observed by the trial court that the petitioner or that the respondent number 2, SPW1, produced a copy of the legal notice as Exhibit 3 and the postal receipt for the same as Exhibit 4. Post of the order dated 7/2/2020 also transpired that the petitioner stated that he could not remember if he had received the legal notice marked as Exhibit 3. Despite the fact that he had denied in his statement under section 313 CRPC that he had received a demand notice marked as exhibit 3, full stop. The observation of the learned trial court is reproduced herein below verbatim, page 35. It more double tick di diso. Page 35 of the petition, double tick, and page 36, double tick. Section 138 is presumption in next parallel. Section 138-39 is presumption in favor of holder. Hyphen next line of Lishida. It shall be presumed, unless the contrary is proved, that the holder, contrary is proved, that the holder of a check received the check of the nature referred to in section 138 for the discharge, in whole or in part, of any debt or other liability. Full stop. Next line of Wikipedia. Similarly, section 118 within bracket small a bracket close of the NIA provides as follows. Next line, presumptions as to negotiable instruments, hyphen, until the next line, until the contrary is proved, the following presumption shall be made, hyphen, next line, small a data deal, small a within bracket, of consideration, hyphen, that every negotiable instrument was made or drawn for consideration, and that every such instrument, when it has been accepted, endorsed, negotiated or transferred, was accepted, endorsed, negotiated or transferred for consideration. Full stop. In this case, next parallel here, in this case, it has been correctly held by both the courts that the petitioner failed to rebut the presumption as mandated by law. Full stop. So a little bit of reduction.
Okay. However, lordship pleases, but we are contesting that there should not be any reduction because contradicting statements on oath, 9 years of litigation. They availed the service. They knew at the time of issuance of check that it is against the service they have availed. On oath line, lordship. In our prayer, we would say that there should not be any reduction in the sentence.
What is he doing now?
Lordship, he is unemployed now, present. He made some construction works, Lordship, he did not get the bill, so he could not pay. But he should have proof it, but he could not prove it also. So he is unemployed, Lordship. But if it's up to your Lordship, whether if he goes to jail also, I think, because he has tried. He told me that I am trying, but he could not arrange.
Let us get the, this is almost done. We'll get the trial court records and then we'll dispose it off. Because let us get the trial court records. It's important for me to go through the trial court and
Lordship
appellate
can
court
keep
record.
it part hard, Lordship, like this.
Yes, I'll keep it part hard. After so much of pains, why should I?
Yes.
I will take it up next week. Next week, kiba alop khali date asa niki? Even if I go to another bench also, it will come up.
Yes,
I will get the trial court records. It will come from which place?
Here only, Lordship,
Gauhati.
Metro.
Trial court record or Harry record original to Lydia. Stay is not granted, no?
No, Lordship.
Okay. We'll get it original. We get the original records. Huh? 28 May, yeah. Heard Learned Counsel, beginning of the is it? Learned Counsel, Mr.
M. Ahmed.
M. Ahmed for the petitioner and Learned Counsel, Miss
P. Gupta.
P. Gupta for the respondent number 2 and Learned additional PP, Mr. G. Busher. K. Busher and G. Busher. He's K. Busher. We have already written his name. K. Busher or G. Busher? K. Busher for the respondent state. It appears that the original records of CR case number 1950 of 2018, as well as the criminal appeal number 23 of 2004 is required, 24 is required, all for the original records from the respective courts positively without fail on 28th of May. If it doesn't come, it will be difficult because I'll have to check the evidence. As part heard. This is matter on as part heard matter.
Item number 18, your lordship.
Mm.
I am mentioned going to be list. Can it be fixed at 2, your lordship? Item number 18
Yes,
or after some.
at 2 years. It
Of
will
like-
at 2. At 2 kiba ase nahi aji?
Item 11.
Can be fixed.
Need to, your lordship.
Yes.
LGR was called for on the last date.
Mhm.
It hasn't been received yet.
Okay.
This case is for causing of a FIR of all women police.
Trial court records.
Yeah.
Trial court record, just you saw what happened now.
Yes, Your Honor.
After detecting half of the judgment, I wanted the trial court records.
yeah.
Parties may not need, but I may need it.
Yes, definitely.
Trial court records as called for is not received. Issue reminder, list the matter on.
Oblige, Your Honor.
Scan copies, no?
Yes, Your Honor. Can go.
Finally disposed of case. No, no.
No, sorry.
Finally disposed of case.
No, Your Honor.
Scan copies. लिख दो.
Item 14.
May it please, Your Lordship.
Mm.
On last occasion, my lord, on 8/4/2026, my lord, detailed report from Iowa was called for, my lord. A matter pertains to, my lord, seizing of, my lord, Erica nuts, my lord.
You have a detailed report regarding the Erica nuts? You want custody of Erica nuts?
I want custody, my
We'll need the report.
lordship, my lord.
This is under investigation or under trial?
Under investigation, my lord.
Taken after some time, my police made a call to me.
CD?
CD has been, they have forwarded the case diary, my lord.
Okay.
Served them with a report.
Oh,
And as per the report, my lord, it is pending to collect the, my lord, attested report, my lord, whether, my lord, it's fit for human consumption or not. my lord.
mm.
Counting Jimma, my lord, edibility is not a concern, my lord, because, my lord,
So that-
No, we will pass, if it is not fit for human consumption, we'll pass another type of order.
lordship.
We have we usually pass an order to not to sell for consumption,
That,
but
like,
can be sold for
Lordship.
making
So-
perfumes. I think
my
perfumes are
lord,
made out of it.
lordship, my
I don't know
lord.
exactly, I have forgotten.
Lordship, my lord. There is an order of this honorable court, my lord, to the effect that, my lord, for consideration of a petition for Jimma, my lord, the edibility of the, my lord, Erica nut is not necessary. my lord.
So pass several orders,
Lordship,
but
there's several orders,
back.
several orders there. my lord.
I have forgotten. Long time back, I have passed several orders,
Lordship.
but I cannot remember. If you can give me a copy of the order, I can pass it on order.
By
Lordship,
After some time?
after some time.
After some time.
Item 16. of the-
Wait, please, Your Honor. Lordship, can this matter be passed on for time being?
Time being, yes, can
Yes.
be passed for time being.
Dictate.
Item 19.
Same prayer, Your Lordship.
Yes, yes,
count
can
it
be
as-
passed for time being.
20. Item number 20.
Bill hearing है.
Item 20.
Case diary, see this, they are not interested. Should we call for wait for a case diary? If they are not interested, they are not present.
That is, so started submitted, I'm sorry, but of these 20 men, they have not present, they are not present.
Petitioner is not represented today. List this matter after 2 weeks. No, 2 weeks or now. This matter on date of the bail petition.
Item 21.
There's an interim order also.
Yes, sir. 11-5 notice sent to the victim.
Huh?
11-5, my lord, notice sent to the victim. 21. Yeah, already in this. Oh, yes.
21. 22 हो गया ना? 20 होल ना? 20 हो गया sir. Learned counsel Mr. H. Das is present for the petitioner and learned additional PP Mr. R.J. Burwa is present for the respondent state, comma, and learned counsel Mr. Huh? Your name?
Z. Dotto.
Z. Dotto is present for the respondent number 2 and has submitted that he has filed his Wakalat Nama today. Do we have the TCR? Can we have called? We have received the TCR. You want to place your submission? You'll file objection. And also has submitted that he will file objection against the bail application. Bail application, no?
Yes.
List this matter on
AB.
against this anticipatory bail application.
Interim will continue.
Interim order shall remain in force till then. Okay, you have an interim order. The lamba date did you? On 16 June. Interim order shall remain 16 June. Interim order shall remain in force till then. Item 23.
Please, Lordship, kindly pass out the matter for the time being.
Okay. Item 24. You have the PD?
May I please? My lord, this is anticipatory bail application, my lord. FIR is at page number 11. Where in this case, my lord, one of the accused granted regular bail and one of the accused granted PRS bail by the landed court below, my lord. I am furnishing the orders. Authorized Das. FIR is at page number 11, my lord. So far as the record, the victim sustained simple injury, my lord, so custodial detention may not be required, my lord. I have given the orders. One regular bail application and one anticipatory bail granted by landed court below, my lord.
Okay. FIR is at page number 11.
11, my lord.
Please read the FIR.
The humble submission is that on last night at about 7:38 p.m., while my brother, namely Pranab Mohanto, son of Sasan, along with his friend Sri Mukotchandra Dekka, resident of Gauhati, Madhavnagar, were going to purchase bricks from an industry situated at village Theusar in their Scorpio vehicle. Unfortunately, 3 4-wheeler vehicles comprising approx 15 persons obstructed them. The accused persons assaulted my brother with pistol and rod with an intent to murder him. They had assaulted my brother badly and snatched a cash amount of rupees 1
What
lakh.
is the name of the brother?
Pranab Mohanto.
Okay.
1 gold chain and also some cash amount approx rupees 20.
Okay, all right, all right.
Now,
Get it.
the affair lodged by us, page number 17, my lord. FIR lodged by Jitu Das, who has granted regular bail, my lord. Page number 17.
Page 17. Okay.
17.
17.
17.
Yes, yes.
May I read, my lord?
Yes, yes.
With due respect, I have the honor, subject cited above. I hereby inform you that yesterday, I on 7/3/2026, along with my friend Ghulam Mustafa Ahmed, went to my sister's house at Bajani, Kamrup, Assam, and I went to Mirja via Devsor from my sister's house. And when I reached at Devsor village, then the above mentioned 15 culprits were blocked the road by a vehicle registered number such and stopped my vehicle without any reason. Accused number 1 broke backside glass of my vehicle by registration number such and directed us to open our door. And when I opened my door, then the accused number 1, 2, 3 were dragging me on the road, and accused number 1 cut my front head by a sharp weapon thou, and the accused number 2 hit my chest by an iron stick, and accused number 3 and 13 other persons were physically assaulted me by delivering kick and punch, and then I fell down on the road. Thereafter, the accused number 1 pointed a gun to kill me and then immediately punished him back. Miles.
So this is the case that is manner. The victim statement also recorded manner. Here statement of this person I know with others manner. They have assaulted him manner. Totally certain injury manner. Manner, as per the medical report manner, the symptoms blood, cut injury manner. Medical report suggested sexual injury. Otherwise, when a victim has implicated manner, but there was also another person manner who was also along with the victim manner. He said that there are 3-4 persons who assaulted him, but he could not identify those persons. Only victim is identified by name.
That this present petitioner.
Present petitioner, along with others.
My lord, shameful imprisonment, perhaps custodial detention may not be required. One of the accused also granted bail by the learned court below, my lord. So, my lord, at any condition, I
Cut injury.
Well, even then, there is no shooting injury, my lord. So the allegation is that the accused person pointed gun and
Arms set, no?
my lord. There is no any arms injury, my lord.
Let me see. Why was this kept pending?
My lord.
Why was this case kept pending? Why was this CD kept retained and why was
On last occasion, my lord, adjournment was short, my lord. That's why.
My lord, Parvez, my lord, informant, my lord, he has paid for time to file affidavit, my lord.
No, my lord, actually, there is no any formally, my lord, the order in the order 6, my lord. That's why I have not filed the.
There are benefits of paragraph below and there maximum up to 1 case pending against a present petitioner. The another case is going on against murder against which speaks on 26(5) for evidence. For a present there is a person our
My lord, I am submitting the cases pending against him, my lord. These are the cases, my lord. No, my lord. Allegation, cross allegation. My lord, if assume there is cut injury, my lord, then section 118(1) will come. That is bailable section, my lord. Not.
Arms Act?
My lord, nothing, no such incriminating materials about my lord Arms Act. That the accused person used arms at the time of committing, my lord. Mere statement is not sufficient, my lord. There should be some evidence, my lord. My lord, victim's medical report collected, my lord, his statement recorded, some of the accused granted antecedent bail, my lord. Only my statement has to be recorded. Whether custodial detention is necessary, my lord. We should go by the section, my lord, 118(1). That is bailable section, my lord.
Attempt to murder is terror. The punishment is up to life. Q102, this is proprietary. Punishment is life also. Rightly answer the case by the investigating agencies.
There should be some evidence that we have looted, we have snatched away some money from them. Independent witness could not identify myself, the petitioner, my lord. Of course, he will state, my lord. No, no. Other witness should be corroborated, my lord.
Charge sheet has been submitted.
No, my lord, not
Then
yet.
how did you get statements of witnesses under 161 CRPC?
No, my lord, that is the, my lord, my learned friend submitted that, my lord, one of the independent witness could not identify the instant petitioner, my lord. So far, there is CD, my lord. Sir, my lord, investigation is substantially, my lord, progressed, my lord. So custodial detention, my lord.
Say about the antecedent, have you mentioned about this antecedent in your objection? Have you have filed any objection?
Yes.
Have you mentioned about his antecedent in the objection?
Please.
Okay, I'm rejecting here as an antecedent.
My lord,
No,
kindly see the order of Ajay Das, my lord.
It was your duty to.
My lord,
produce the
kindly peruse
antecedent for the other.
kindly peruse the order of Ajay Das, my lord. My lord,
See, I am saying.
NDCD bill granted by the lower court below to one of the accused, my lord, Ajay Das namely.
Then why don't you prefer anticipated bail application before the lower court? I'll be rejecting it.
No, granted, Ajay Das bill granted, my lord. More কথাটো কোৱা নাই। More কথাটো কোৱা নাই।
I benefit my objection, so it is paid. The rejection order.
Where is this antecedent? Only if you have the antecedent in the additional affidavit, then only I can reject the bail. Otherwise, I will grant the bail. If you have any, because this loose paper will not work. If you have mentioned about his antecedent affidavit, then I'll reject the bail. Otherwise, I'll grant the bail. Page 45. So this is medical report.
Medical report.
No, about his antecedent, you are submitting something. No, that won't work. Now, this court won't rely on downloaded copies. You'll have to submit with. Why should I? Why
So,
should
my
I
lord,
take
at any
personal
at any stringent condition, my lord, I will appear before the investigation agency. At any stringent condition, my lord.
Specifically mentioned about one business lawsuit, it is pending lawsuit. Page 11 lawsuit. Oh, sorry, paragraph 11 lawsuit, it is page.
So, my lord, my intention is not evil, my lord.
Page 7 lawsuit.
I have clearly disclosed, my lord. If I have any evil intention, then I would have suppressed this case also, my lord. So my intention is not bad, my lord.
Page 11. Okay, okay, this is the case.
I myself stated, my lord.
All right.
I have not suppressed, my lord.
There also attempt to murder is there. In that case, that is
My lord,
also pending.
mere allegation is not, I am not
Rejecting.
convicted, my lord.
I'm rejecting hard learned counsel, Mr. A. Paramanik, for the petitioner. Ghulam Mustaq Ahmed alias Mullah Mustaq Ahmed, who is prayed for anticipatory bail in connection with so and so, PS case under so and so sections. Heard Mr. Ajay Borwa, learned additional PP Assam, and learned counsel Mr. B.K. Soria for the informant, for appearing for the victim. First of the allegation against the petitioner is that he, along with his companions, attacked Pranab Mohanta. Pranab Mohanta, no?
My lord.
Pranab Mohanta, causing injuries on his person. Full stop. The learned counsel, B.K. Soria, no? What is his name? P.K. Soria. The learned counsel, Mr. P.K. Soria, has submitted an objection, and to the objection it is submitted that the petitioner has sustained injuries on his head which had to be stitched, and he had to and 8 stitches were and the report marked as, and 8 stitches now, and the report marked as annexure what? Eight stitches. Naragi. What is this annexure? Annexure 1 series at page 41 and page 45 reveals 9 stitches had to be removed. 9 stitches were removed from the head injury. Full stop. The learned additional PP has also submitted that the victim has sustained several injuries on his head and other parts of the body. Full stop. They are incriminating materials in the case diary against the present petitioner. Full stop. The learned counsel for the victim has submitted that the petitioner is undergoing trial in a case under section 302 IPC. It is also submitted by the learned counsel for the petitioner that the petitioner is also implicated in a case registered as Boko PS case number 291 of 2025, which also is registered under 27(1) of the Arms Act. Full stop. The petitioner at present is also registered under Arms Act. Full stop. I have considered the submissions at the bar with circumspection. It is submitted that the co-accused have been granted bail. The learned additional PP has raised objection stating that parity cannot be considered in cases of offenses of this nature. Full stop. I have also scrutinized the case diary. Stop. Indeed, there are incriminating materials in the case diary against the petitioner. Full stop. At this juncture, to criteria, the petitioner has admittedly the petitioner has other criminal antecedents. Full stop. In view of my foregoing discussions, at this juncture, it appears that the petitioner appears that the privilege of anticipatory bail cannot be extended to the petitioner at this stage of investigation. Anticipatory bail petition stands rejected. Send back the CP.
Time being item 23.
Wait, please, Your Lordship. It's a pre-arrest bail, my lord. I have been protected by the order dated 19/3/26 and I appeared before the IO also, madam.
Yes, you have the CD.
Lordship, you'll find the FIR at page 1717. It's regarding, my lord, coal, my lord, that was carried in a vehicle, my lord. And the police, my lord, apprehended this vehicle saying that, my lord, no proper tax invoices were there, my lord. In fact, I have, my lord, annexed those invoices in my petition.
My lord, initially, my lord, the driver was arrested, my lord. So driver, my lord, when he was arrested and he was interrogated, my lord, he has implicated the owner, my lord, that as far as it's concerned, my lord, they have carried the pool, my lord. Now, my lord, during investigation, my lord, the invoice, my lord, these were all verified, my lord, and these are all fake, my lord. Fake enforcement. That were submitted along with the, my lord. While my driver was arrested, my lord, this fake my lord, invoice were submitted to the investigating officer. But during my investigation, it was found that these are invoices are fake enforcement.
No, the invoice I have annexed, my lord.
Fake.
Fake. No, annexed for again.
Mentioned in the case diary.
My lord, no, my lord. His submission is of two part of installment, my lord. First, he said, my lord, the document which were seized from the driver were fake. During investigation, it is found to be fake. And I have annexed the document tax invoice with my petition, whether they are fake or not, my lord.
Those are fake. That is what he is saying.
Clearly, if it is fake, then, my lord. And I have submitted the original one, my lord.
You need some time.
That is come day after tomorrow.
Day after tomorrow.
I'll also bring the original one. Original fake certificate.
To an affidavit.
To an affidavit. That in that case, my lordship may give my 1 week time, my lord, next week.
1 week time.
1 week. Anyone?
Learned Counsel Mr. N.J. Doctor is present for the petitioner and has prayed for adjournment. Learned additional PP, Mr. R.J. Borua, has prayed for some time to go through the case diary. List this matter on 1 week time, did ya? CD to be retained till 25.
Can it be after my lord 28? 29 তারিখে দিও কেন? 29. I'm obliged, my lord.
CD to be retained till 29.
The interim order shall continue.
Interim order shall remain in force till then.
Will tell the case then.
Yes, yes. Will, otherwise it won't be, it is from which place?
My lord, in item number 20, my lord, I have missed the item, my lord.
20, I guess.
20, my lord. The CD is not received, my lord.
Just a moment. What is the order? Item 20. Learned Counsel Mr. T.K. Bhuya is present for the petitioner. CDS call for is not received, issue reminder, list the matter on lamba date did by interim order আছে. 18 of June. Interim order shall remain in force till then.
Obliged, my lord.
Admin item 16.
Can this be in the second half, dear Lordship?
22nd,
No, second half.
second half.
Yes.
Yes, can be
It's,
on second half.
16 and 19.
Already I have fixed one more matter at 2.
Yes.
It will come after that.
16 and 19.
Hmm.
Tribunal.
16 and
19.
19, okay.
Yes.
Yes.
Item 25. Your lordship may also take up item number 30.
Item number 30,
30 and 25. Both
TBI?
the actions are take person.
DRI,
Yes, you are.
25 and
30. 30.
30.
Himanshu Bose. In item number 30, show cause notice has been issued, which is akin to a charge sheet, that the customs act. And in item number 25, it is the process of the
We shall take up now, 30 or 25.
both of them, your lordship, in 30, the 25, I have submitted a bail objection as to what is the involvement of the petition applicant. In that case, in item number 25, item number 30, this is the, I have just marked that this is the show cause notice. And this is a whole involvement, actually maintaining the whole involvement of the petition. In Master Post, I have marked that, your lordship.
Okay.
So, in fact, he's the kingpin of this whole racket. He's a smuggler involved in smuggling of poppy seeds. It is used, later on used for opium. So, it doesn't come under NDPS, but it is controlled.
Poppy seeds is turned into opium.
Opium. It's an opiate. So, that's why it's illegal. As for I have also mentioned that particular order, which actually illegal, which declares that it is an illegal product. So, and it's a huge quantity. And he was the main recipient of this whole poppy seeds, which was confiscated, big trucks, pretty large trucks. So now he has filed his NDCP bail application, which cannot be granted by honorable commission. Because he is the main person and he has not appeared so far.
Here, see, here in this 25, item number 25, AB 745 of 2000.
Yes, he has been granted.
26 was granted interim bail.
Because one of the accused, his involvement is not that much. He was granted bail, and on the basis of parity only, he was granted interim bail.
And has he appeared before the IO?
No.
Clear that the petitioner has received the summons for appearance before the IO. He shall positively comply with the said summons and appear before the IO.
In that item number 25, he went there, but the IO, he was involved in an operation in Manipur. So on that day, he was not present. But in the item number 30, he was not granted interim bail because I have produced that instructions wherein his involvement is very much there. Similar to item number 25 and 30.
These are two separate cases. One is case number 14, another one is case number 18. Now, in case number 18, item number 30, show cause notice has been issued under section 124 of the Customs Act. And now the matter is pending adjudication, just like a trial court, it's pending adjudication before the Joint Commissioner for Customs, Shillong. So if he wants to go for a regular bail, he can approach the authorities there. But he has been avoiding arrest, and he has been avoiding giving.
In item number 30.
30, because he has not been granted interim protection there. And I have mentioned his involvement in item number 30. He is the main.
That customs office is in Shillong.
Shillong, the headquarters.
That commissioner's office
Not
is in
the
Shillong.
commissioner's office. So I have mentioned, I have highlighted his involvement. I have flag marked the involvement, and his wife is also involved. His wife is also, his wife's case is today listed before Honorable Justice Party Judge Sekia, court number 8, number 9. So in fact, his wife involvement is also Jyotsna Bose. I have flag marked there. But I perhaps all those cases need to be tagged together.
Tagged together,
And
yes.
listed together so that I can highlight each and every person's involvement. Him, Himanshu Bose, and his wife, Jyotsna Bose. So some date may fix your lordship.
May I please, your lordship?
On that day, in fact, I mentioned before, court number 8 today also, I think this is item number 59, will come after some time. So that matter will also, maybe also be listed along with all this item number 25 and 30 on a once particular date, so that it will be easier for the court to actually peruse the.
You see, item number 59, I cannot say anything about it
Yes,
because
that's why.
that court may dispose of the matter altogether.
The different court altogether. So I'll bring for that particular court to be listed along with this item number 25 and 30. Because all of them involve the same offense and.
No, say item number 25, you see, this is not his fault. I was in a operation in Manipur.
Yes.
So
Now he has appeared.
Now he has appeared.
Later on, he has appeared.
So you want me to cancel the bail? Granted
Yes,
to him.
yes,
May I
because
please, your
his
lordship?
involvement is there.
I'll start with item number 25. Your lordship, actually in May 13 and 14, he has visited the DIR office twice and his statement has already been recorded. In this case, he has got interim bail order. Your lordship, I think the goods which have been seized from the premises does not belong to him. This belong to one of the co-accused mother. So he has no direct link of the possession was not got from his actual possession. The goods has not been seized from actual possession from his premises. I mean, your lordship, I think your lordship, this is related to foreign secret, not property secret.
That is forensic.
The foreign secret, which where he got the interim bail. And this.
One is with regard to confiscation of foreign secrets, and the other one is with foreign secrets plus officers.
So
he had got the bail in the foreign secrets.
Forensic. He has got the interim protection in the foreign secrets.
Your lordship, in this case, he has already got the interim bail. And
what
he
is
has
the
not
extent of punishment in foreign cigarettes?
Basically
7 years, up to 7 years.
years.
7 years.
So you let's make this absolute. He is appeared with this item number 25. I'm making the absolute, not the other one.
Your lordship, in item number 30.
No, that
he has already he has replied on the show cause one.
not that case. This is how many kilos? Where is the FIR item number 25?
Around 9,000 kilos of.
What will be the value?
Value, the end of cost. Value is not there in the summons also. I think it's there.
It's okay.
So
It's okay. Okay, where's the FIR? Complaint or FIR, what do you call
The
it?
complaint case,
Oh.
FIR is not annexed in the bail application.
Okay,
So summons was issued each time.
on the summons, where is the summons?
Page number 8.
Page 8.
This is I'm talking about item number 30,
No, 25, I'm talking about 25.
25. Page number 7.
Page number 7.
Regards to item number 25, I've submitted to the bail objection, which is there, and I've just submitted this.
Item number 25, no?
These 2 page,
Where is the allegation in item number 25?
allegation is your worship, they has actually challenged the summons. Actual 1 page 7.
This is not bail application. This is an anticipatory bail application.
Anticipatory. bail.
Yes, your lordship.
There's no FIR.
Where is their allegation, whatever it is?
The summons is there, your worship.
Summons is there, but there's
Only
nothing
the
in the summons.
Only the summons,
There's nothing in the summons.
nothing there.
Hmm. Standard council, Mr. Item number 25, huh? C.
As sir, my lord.
S. Sarma. Your name is not in the first
List of the
installment?
advocates, his name is there.
Huh?
My name is there in the list of the advocates.
On
S.
behalf of learned counsel, Ms. C. Sarma.
So, no problem.
For learned counsel, Mr. S. Sarma, on behalf of learned counsel, Ms. C. Sarma. And learned
T. Bora, senior standing counsel.
senior standing counsel, Mr. D. Bora, no, for the petitioner, for the petitioner, Himanshu Bose, who has filed his application under section 483, 482 of the B and WS 2023 with prayer for free arrest bail. Itu heri paragraph 2 লিখিবা গুটেখিনি তাৰপিছত তাতে গুটেখিনি লিখা আছে in connection with এটো how Mr. Senior how learned senior standing
T. Bora, senior standing counsel, DR.
senior standing counsel DRI Mr. D. Bora I have considered the submissions at the back from our learned standing counsel for DRI laid stress in his argument that the petitioner was granted interim bail by the order dated 7/4/2026 as on the ground that the co-accused was granted bail by order dated 23/2/2026 in AB number granted pre-arrest bail. By order dated 23/2/2026 in AB number 384/2026. In connection with the same case. Full stop. The serious objection has been raised against the petitioner, stating that the petitioner has earlier antecedents of smuggling poppy seeds as well. Despite the fact that this case is not related to smuggling of poppy seeds, full stop. The objection raised against the petitioner is that he was held to be smuggling 7,19,120 sticks of foreign origin cigarettes of the brand within inverted commas ESSE special gold bracket inverted commas close and Godangaram GUDANG within inverted commas GARAM collectively valued at rupees 1,79,78,000. it is submitted that the petitioner is a history sheeter and his wife is also indicted in another case. Full stop. It is however, it is admitted that the petitioner has appeared before the investigating agency and he has cooperated with the investigation.
His recorded
Okay.
statement, Your Lordship.
His statement has been recorded. I have considered the submission that the petitioner has not violated any bail conditions. He's from which place?
He's from Goalpara, Your Lordship.
Balpura. The petitioner being a local resident is not a flight risk. Considering the entire aspect of the matter, the interim bail dated 7/4/2026 is hereby made absolute under the same terms and conditions. What is this called? CD?
These are show from.
No, the entire thing. What is this called? Offense report or CD?
No, it's a show cause notice.
This entire bundle?
Entire.
Okay. I also perused the so-called notice submitted by.
No, you'll have to check the item number
Thir-
30. Not.
Okay, I have number 30. So we'll keep it pending or we will
Yes, sir.
dispose it of?
Your Lordship, make it be pending, Lordship, because in the item number 30, he has already replied on a so cause notice on 4th May. He went to the DIR office also and submitted his so cause reply.
Okay, then you
He'll
take it
face the
back.
trial also if it required, because already have
You take it back.
After some on some date, after 1 week, you know. get
Okay,
the-
okay.
Some date maybe.
একেটা নামেই লিখি দিবা তাৰপিছত বাকী হেৰি একে DRI কেছে হয় চাই ল'বা তুমি তাৰপিছত লিখি দিবা লাৰ্নেড কাউন্সিল নাই এইবোৰ নালাগে লিখিব আৰ্ট মিষ্টাৰ চি শৰ্মা এছ শৰ্মা
Yes, sir.
28.
representing the petitioner who has prayed for adjournment list this matter on when do you want
28. 28, you know.
on 28. Meanwhile, the show cause notice submitted by the learned senior standing counsel, DRI Mr. D. Borano,
Yes.
is returned back. I'm on 26.
Item 26.
26, well, CD not.
Also kind to see the FIR minor. Allegation against father-in-law. And 4 months ago occurrence, this was filed, she left, and she is now with that minor. Husband is supporting her, this is the allegation. Page 9.
Page 9.
Page 9. It is dated 1/2/25. And ¿qué pasó, joven? No. ¿Qué pasó, joven? ¿Qué no fue? No, la veo por el-
Yes.
And kindly see paragraph one, just my lord,
Paragraph,
one paragraph 3, my lord.
paragraph 3 of
Paragraph 4, my lord,
paragraph 4 of your petition.
petition, my lord.
Yes.
Page 4, my lord, just however, some,
Page 9 is the FIR, no?
yes.
Paragraph 4.
Paragraph 4, oh no, page 4, my lord,
Page 4, yes.
page 4. It starts from Actually, paragraph 3, page 4. However,
Okay,
I lift your lordship.
we'll need the CD.
Only when a custodial interrogation.
We have the scan TCR, okay.
TCS.
Oh,
We have the scan TCR.
oh, already called for it.
But the CD, we'll need the TCR will not work. We'll need the CD.
Now, TCR, I think CD includes more than a TCR. Huh? Custody, who says? Oh,
Oh, we
custody,
have the statements of the witnesses.
yes.
We have, it's okay. It will serve. You want to go through it? We'll go through it.
Something
You can sit down.
something improbable in the Indian society, madam. This the husband is supporting her, I don't know. The father, madam.
One is there, one is only go to now, one is
183 and other statements also are there.
one is clear now.
$62 years age, man. 62 years old man, man.
As per the statement, one is
That she will corroborate what FIR she filed. Only your lordship, who the probability is there, madam.
The witnesses I'll see.
Other would know only husband. Accused, madam. Husband is just one. Hmm? Only two for husband and his father-in-law. Hmm? You co-pocket madam the investigation. This is only thing. So 62. Custodial interrogation, I think in this case is not required. Someone is going. 14, 10, 1, 2. Yeah, okay, put it in.
You see the statement under 181 CRPC of the victim? Just check. And the statements of other witnesses also.
Yeah, okay.
Any other ground?
Basically,
Ailment?
yes, 62 years in also, my lord. Otherwise, separate living. She is now with the child is there 8 years time. My lord. 10 years ago, marriage took place. And there is a problem of my lord, compromise also. He got some paper also, my lord. That is also going there. Because of the child, my lord, everybody wanted to have some relation. But she already 2 times, my lord, there is compromise. 2 times she left.
There's more about it.
180, no? People are rejecting it.
No, this is my her statement to whether your lordship takes custody indication requirement. That I am, that will come, my lord. In the meantime, someone also issued, I think, my lord. Only one that, my lord, for the year, my lord.
So,
He will appear, my lord.
Sausage has been submitted.
I have been told now, just now he got from that, someone issued and today date was fixed, my lord, today.
So you appear.
No,
You
he-
will be granted bail. You withdraw this.
My lord, huh?
Someone is there. Oh, no.
You appear. I think you withdraw this. I think you.
My lord, your lordship will appear on the next date of appearance, my lord. In the meantime, your lordship can give that. No, that your lordship can, I think, my lord.
Have you approached the court earlier?
No. Because charge sheet filed subsequently.
Not good. And then they have brought up, the accused party have brought up, they have brought up some allegations against the victim. This is not good.
No. If it is a fact, but I do not know. Nobody can say, my lord.
No, they have stated in
But sometimes it
161.
happens.
Accused has given his statement in 161. All the accused, they have, doesn't appear to be a true fact. Doesn't appear to be true
Only
facts.
the money you will appear, madam, that day bail may that your lordship.
If it is rejected the same day itself, I'll grant bail.
Hmm.
I'm sure if you appear before a 62-year-old,
No, your lordship, with some observation, your lordship will dispose it. I am not pressing bail.
I'll reject it and I'll
No,
dispose it
no,
of.
once rejected, it will
So
be given.
then that is what I'm saying. You withdraw this, you
No, madam, your lordship may say without disposing here, I ask them to appear before that comes, my lord.
yes, appear before
Without
the-
disposing,
yes.
not reject
Yes,
my
yes.
what rejection should be.
Our learned senior counsel, Mr. H.R.A. Chaudhary, former assisted by learned counsel, Mr. A.R. Karim, for the petitioner, Samad Ali, who has filed his application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as is apprehending arrest in connection with
With Agamani PSK numbers also.
Sashi has not been submitted, no?
Actually submitted one, that's why. Yes.
Then it will be a special,
Sakshi submitted on
it will be a sessions case, I think.
No.
session case till now, I think not. Yes.
Okay.
Yes.
It is in the
Sakshi submitted on-
CJ, it is in the magistrate's court.
0725.
Agomini PS case number so and so under section so and so, within bracket GR case number so and so. Heard Mr. KK Porosha learned additional PP Assam. We have scrutinized the scanned copies of the trial court records along with the scanned copies of the CD. The allegation against the petitioner is that the petitioner, being the father-in-law of the victim,
Agent,
committed,
age is 62 years.
committed sexual assault on the victim X, full stop. It is submitted that the petitioner is 62 years old and as Sasid has been submitted, his custody is not required. Full stop. The petitioner is willing to cooperate with the trial. Full stop. It is submitted that being 62 years old, the petitioner will suffer immensely if he is forwarded to custody at this age. Full stop. It is further submitted the victim, on the other hand, was caught red-handed indulging in extramarital affair, and a false case has been brought up against the petitioner. And thus a false case was brought up against the petitioner. Full stop. I have considered the submissions at the bar with circumspection. Full stop. It appears that the petitioner is willing to cooperate with the trial. He has been shown as absconder. He has been shown as absconder in the charge sheet. Full stop. As the petitioner is willing to cooperate with the trial, from a pragmatic view is taken, and the petitioner is directed to appear before the learned trial court and apply for bail, which may be considered by the learned trial court.
Trial court,
Learned court
court below.
And nowadays we are debarred from mentioning court below.
Court below means ultimately it was.
Court, all this type of
No,
words.
court below, they will interpret it that way, my lord.
So we will have to mention as Elaka Magistrate Jurisdictional Court. Elaka Magistrate to Jurisdictional Court and apply for bail, which may be considered by the court in accordance with law.
Obliged.
The POSCO Act, Your Lordship, herein the petitioner was arrested on 2/11/2025.
POSCO Act.
Yes,
What about the respondent number 2?
yes, and this is the order sheets.
There's nothing about respondent number 2. Step received notice issued to respondent number 2. But no.
My lord, in this matter, in 18, my lord.
Now, Your Lordship, under section 35 of the POSCO Act, the case there should be a speedy trial. And after taking cognizance within 30 days, the victim's statement has to be recorded. That has not been done. Your Lordship.
No. We will have to serve the notice on respondent number 2.
As part of notification.
And there is nothing about the notice. We'll have to wait one short date.
Yes.
We have the scan copies.
Scan copy is already here.
You can keep this with you now.
I will produce on the next date, Your Lordship.
Yes, on the next date. Service report on respondent.
Otherwise, I am under detention more than 6 months, Your Lordship.
I am sorry,
There are
but can't help it. We'll have to serve the notice on respondent number 2. Or else shall I appoint a legal aid counsel?
We've taken
Okay.
the notice, man.
Service report on respondent number 2 is awaited. List the matter on. Then next day you take instructions.
Yes, sir.
Short date, maybe, Jim?
26 May.
26, I will not be here, Your Lordship. 28.
16 or 19 একেলগে কৰিম বুলি কৈছিলে পাছত অলপ সোনকালে উঠিলো নেকি অলপ পাছত আহিলেও হ'ব 16 or 19 to
May it please.
Yes,
Here, my lord, report was called for, my lord.
do you have any report?
14, my lord, that is, my lord, the Arakan of, my lord, that is, report is awaited, my lord. They have sent, my lord, at the city, my lord. So we pray for a short accommodation, my lord. They send it for, my lord, that is, district.
When did you get the CD?
Yes, my lord. CD we have, my lord.
When did you get the CD?
My lord, CD we received on, my lord, 2nd of May 2026, my lord.
We do not want the CD. We are keeping the CD for 2 weeks.
Right.
We'll send it back.
Yes, my lord.
We only want a
We
report.
only the part of the report. my lord.
Learned counsel, Mr.
K. Burua, my lord.
K. Burua is present for the petitioner and learned additional PP. Mr. K. Burua submitted that CD is received, but the report relating to the Erica nuts is not received. Call
Yet
for
to
a
be
report.
collected, my lord.
Huh?
That is yet to be collected.
Call for a report relating to the Erica nuts is in connection with this case. Send back the CD. Send back the CD. List this matter for report on short dated. We'll get the report through
Fine.
email also, WT also, so no problem.
Oblige, my lord.
Item 27.
Yeah, please, your lordship. This has been pending for the last 3 days for service report, my lord. Perhaps service report is still not received, my lord. May I pray, my lord, that an amicus may be appointed, my lord. TD has also been lying there for the last 3 days, my lord.
Hey, Harry, Amicus Curie. Your friend is Amicus Curie?
Who, my lord?
Yes, does.
Asdas may not be appointed because, my lord, his name is.
On the other side, okay. Learned counsel, Mr. S. Nawaz is present for the petitioner and learned additional PP. Mr. K. Bose is present for the respondent state. It is submitted by the learned counsel for the petitioner that this case is pending for service report of to respondent number 2 on 3 dates. Full stop. It appears that an amicus curiae may be appointed. This curiae may be appointed. Okay, Sri Ona Pukon is appointed as my amicus curiae to represent the respondent number 2. This amicus curiae is listener.
My lord.
No legal aid counselor, right? Okay.
I'll serve a copy, my lord. on him.
A copy of the petition to be served to the amicus curiae.
Well, can it be taken up on 22nd, my lord?
List on, yes.
22nd?
22nd.
22nd.
22nd, okay.
I'm deeply obliged.
We have the scanned copies of the records, no?
My lord, CD is there. That may be retained, my lord.
Okay. CD is received, CD to be retained till 22nd.
Yeah, deeply.
Item 29.
May I please,
Yes.
Lordship, matter may pass over the time being.
Okay.
Item 31. 31.
You have the CD? 31, no. CD as called for is not received. Issue reminder, list the matter on 29 May.
Item 32.
May please, your lordship. Here in the petitioner, they are the husband and wife, your lordship.
You have the CD? Husband, wife?
Yes.
Both the petitioners are husband,
Yes,
wife?
yes. Asada? Only 2.4 kg ganja was recovered from.
After some time, after, my lord, in 31, my lord, it is my lord, lordship file.
Okay, but the CD call kora hoise no? Okay. Call for CD nalage. Etu, huh? Huh? Issue reminder, etu likhi diya, learned additional PP, etu kati gaya, learned additional PP has submitted there. Shashid has been laid against the petitioner. Very, Petitioner is at liberty to approach the jurisdictional court for bail, which may be considered by the court in accordance with law. Charge sheet number?
Sorry, ma'am, sorry. CD may be problem.
Okay. Issue here.
Sorry.
So 32, you will check the CD? You have the CD?
My lord, 32 CD is here, my lord. So kindly take up after some time.
Okay, sure.
Sorry.
After some time, yes.
I don't have anything.
May it please your lordship.
Yes.
My lord, here, my lord. Appear at page 9, my lord. Actually, my lord, the page 13 is the relevant portion, my lord. Actually, the petitioner and the
My lord, this also, my lord, for time being, my lord. 32 and 33.
After some time.
34.
May it please your lordship.
Mm.
Look, we have prepared, our statement has been recorded, my lord, and further statement fixed on 22nd. So may I pray at this, my lord, since Friday for our next appearance for statement again, my lord. So get with update case there on fixed on Monday, my lord.
Not required.
Yes,
We'll fix a longer date.
yes, my lord.
Yes, we'll send back the CD.
Yes, please.
Learned counsel, Mr. P.K. Data is present for the petitioner and has submitted that the petitioners Sanjit Nath and Rumi Nath, petitioners Sanjit Nath and Rumi Nath have appeared before the
IO, my lord. Authority.
IO, and the
Yes.
statements have been recorded, and another date is fixed for the appearance before the IO, that is
On 22nd May.
on 22nd May. Full stop CD is received, send back the CD, call for the up-to-date CD, list the matter on lomba date detail.
Much obliged, my lord.
List the matter on 10th of June, call for the.
My lord, can it be on
up-to-date
12th of June, my lord? 12th of
12th
June.
of June. yes.
Much obliged.
Item 51. My lord, interim order shall continue.
Oh, yes. Interim order shall remain in force till the,
Much obliged.
till then.
Much.
Item 41.
Service report on respondent number 2 is awaited. List this matter on scan copies to Palu. 2nd June.
Item number 35 for orders.
মই পাছ কৰিলো কিবা সাৰ্ভিস ৰিপোৰ্ট থাকিব Service report on respondent number 3 is awaited. List this matter after 1 week. List this matter on date eta di dia. Appeal hoy.
On the first of
Purana appeal heta.
item 36.
I beg pardon, Your Lordship. Item 41, Your Lordship. CD may kindly call for Your Lordship. TCR receipt actually sachet not submitted, Your Lordship.
Okay.
Wrongly it is
We have the scan TCR.
sachet not submitted, Your Lordship. Wrongly
Okay.
TCR was called for.
Item number
41.
41. Call for the CD video.
41.
And respondent number 2 service report is also awaited.
Someone told me that he will appear, Your Lordship.
Okay. Respondent number 2 has appeared. Nobody has appeared. Let it be.
But,
We have already.
CD may
fixed
kindly call
CD.
for Your Lordship.
I am present to video. Learned counsel for the petitioner, Mr. AR Karim is present.
CD may kindly call for.
Yes, CD. Can call for the CD video.
Lordship.
Date to 2nd June. Shorter date.
Short date, Your Lordship.
Shorter date division. 29 May.
Item 36.
Then where kiba ho service report.
Wait, please, your lordship. Item 36.
Yes. Yeah.
As per order date 1/4/2026, we are required to take steps. On 21st/4/2026, we took the required steps, but in the office to this, no such case serve or not.
You have taken
is not declared.
steps.
We have taken the steps on 21/4/2026.
Mr.
MJ Hazarika.
MJ Hazarika on behalf of Learned Counsel Miss P. Buragoy
No.
has submitted that steps have been taken, but it has not been reflected in the office note. TCR to Palu Niki. TCR has called for is not received, issue reminder. List this matter after 2 weeks. 2 weeks?
Your date may be fixed.
Date at the media. List this matter on 9 June.
Much obliged.
Item 37.
Please, your lordship, service upon respondent number 2 is awaited. And TCR is also not received.
Learned Counsel for the petitioner, Miss
A Lala,
A.
Lala, LA.
A. Lala is present. Service report on respondent number 2 is awaited. List this matter after 2 weeks. 2 weeks? No.
Lordship, a date may be fixed.
List this matter on TCR to পোৱা নাই না কল কৰা হৈছিলে নেকি criminal petition TCR you want the TCR
Record may be called.
This is related to what?
Criminal petition. Lordship, this is a POCSO case.
POSCO case relating to washing
Related.
criminal petition it may be relating to washing
Setting aside of order, Lordship.
setting aside an order okay
Washing.
maybe may not be required nalage scan copies of TCR nalage no paper waste ho mission
Item 38.
Lordship, date may be fixed. Kind.
or date relation 2 weeks sir that AST is requesting us not to fix dates this is a new case that is why
38.
service report on respondent number 2 is awaited list this matter after 2 weeks.
Pending item 32.
What should I say?
Actually,
Okay. Learned Counsel, this is AB, you are not behind bars, no?
No.
Learned Counsel, Mr. K. A.M. Khan is present for the petitioner and learned additional PP, Mr. B. Sharma has submitted that the matter will be taken up by learned additional PP, Mr. K. Paresha. List this matter on day after tomorrow. Friday.
22nd.
Obliged.
On 30th, item number 30 is same.
CD to be retained till item number 30.
3 minutes.
3.
Right.
No, no, it include logo. My lord, here, my lord.
You are not arrested. We'll take it up on Friday.
My lord, but my lord, service is complete, my lord. If possible, my lord, maybe taken on tomorrow also.
Tomorrow. DB also single. I have DB and single boat tomorrow.
But here, my lord, the matter has been, my lord, settled, my lord, amicably between the parties, my lord. And my lord, page 9 is the, my lord, page 13 is the 11th portion of the FIR, my lord.
And the Belag sorted, you are not behind bars. Don't worry. Matter is settled. Who will arrest you? 21st May. 21st May.
In first place.
Thursday DB আছে নেকি আকৌ Thursday to hearing day হয় না on Thursday.
21.
At 2.
At 2.
Learned Counsel Mr. নামটো বেলেগ কৰি বাকি খিনি একে আগৰ নিচিনা একে our presence to be as Munni is present for respondent number 2.
Obliged, my lord.
My lord, CD was called for, my lord, CD will receive, I think, my lord. In this case, my lord, lawsuit may kindly see FIR page 8, my lord. And it's a case of, my lord, 2015, my lord, CIDPS case number 18 of 2015. As per my information, still charge sheet has not been filed.
Charge sheet has been submitted.
No. And so far,
In this case, my lord, the present petitioner used some other people's, my lord, ATM card. It was some money. And ultimately, my lord, one person, the victim, my lord, information was, my lord, blackmail, blackmail by some person, my lord. And there are so many, there are, my lord, 3-4 persons are involved. It's my lord. And the present petitioner also from the Western. From Western. And ultimately his involvement is also clear, my lord. This case.
my lord, so far inquiry report, my lord.
Find, my lord, FIR.
2015 you have not submitted charge sheet
Yes,
till
lord.
after 11 years.
And my lord, one of the co-accused has been granted AB, my lord. I have annexed this order, page 18.
How much money did he withdraw from others?
My lord, some part, my lord, in the FIR, my lord, lordship will find, my lord. Then in the first part, my lord,
18,000.
18,000. Then first part 18,700. And then, my lord,
25,000.
25.
Where is the FIR page?
FIR is page, my lord, 8. My lord, she has not withdrawn, my lord. Another main accused already arrested, my lord. They also released.
Sujata Basumata.
Yes. Her name is not there, my lord. In the
Page,
inquiry report,
page which page?
page 88, my lord.
Page 8.
FIR.
Person may avail.
This person committed suicide.
No.
Complainant.
No.
That is the
No.
But he was deciding to commit
deciding,
suicide.
my lord.
She was decided.
FIR was, I,
Secretly submitted that. Now it's become open. This was secretly, my lord, submitted to the superintendent of police because of, my lord, the fear of that person.
Facebook friend, ultimately he was targeted. Because Facebook friend, ultimately he was targeted.
Next. There is inquiry report, my lord. My CID inspector, there is an inquiry report, annex, my lord, annexed 2, page 17. In this inquiry report, her name is not there.
No, there are materials he has stated, no? There are materials against her, no?
Yeah. And kindly available for just one statement.
Okay, please give it.
Our involvement is here.
Sujata Basumata, no?
Basumata.
His brother, sister,
Yes,
sister and brother-in-law.
yes.
They have received the money, no? Mm.
My lord,
His brother-in-law, he was in Nigeria, then he went to UK.
Yes. The main
Culprit,
culprit. The accomplice.
accomplice. His wife
One-
is an accomplice.
one my lord, Drusilla Basumata, she was granted a
Yes.
bail, my lord.
Who?
Drusilla Basumata,
Who is she?
lordship, page 18, my lord.
No, but she's her husband and they have received money.
Lordship, she and husband.
Her husband and
She,
no, she and her husband, they have received money and they were transferring it to the account of her brother, Philip Kem. What is his name?
Philip, my lord, he was arrested.
Champa Marine ki.
Yes,
He
he
was
was
arrested.
ultimately arrested, my lord. And this honorable court also grant bail, my lord. I have another person, my lord, Birajlal Yadav, alias Biraj.
Why she has not been arrested, this woman? She is more involved than.
Actually, she hails from West Bengal.
Hmm.
One of the things. And my lord, 41 in notice was served twice.
On her.
She did not respond.
My lord, I will cooperate, my lord, since I am before your lordship, my lord. So, my lord, I want to cooperate. My lord. And my lord, this person,
Now, now why you are before this court?
my
For
lord,
so many years, after so many years,
because my lord, police searching me, my lord.
police is searching for you.
Yeah.
41 in notice.
Second time, for the second time.
No, my lord, first time.
You have any objection?
Well, that is my objection, man. That is, he's quite involved. She
He is
quite
involved.
in this case.
Neck deep.
This time.
So I will cooperate, my lord.
And
I approach.
my lord,
Yeah.
Money will be how much total? 1 lakh?
No, my lord, no. This is
15
15,000, my lord.
In one occasion, 18,700. In another occasion, my lord, it is 25,000 something.
My lord. This is, my lord, informant also, my lord, make some wrong also, my lord. Because she believed like this person, my lord. Without any identification and
This happens in Facebook.
that's why.
Some people have died also.
Lost.
And my lord,
Being
hopefully,
Facebook friend and being Instagram friend, some people have
That's why,
died.
She is going to die, my lord, almost.
She was about to die. Yes.
About to die. And my lord, from some people
Hmm.
gathered around her, my lord, ultimately
She was about to commit suicide.
about to commit suicide.
This happens if you become Facebook friends.
Yes, my lord, that's. So I will, my lord, any condition, my lord, similar person has been granted, my lord. She was also from the West Bengal, my lord, Alipurduar. Page 18, page 18.
Ensure, my lord, are available.
Yes, yes, my lord, any condition.
They made a scapegoat out of her.
Yeah.
Complainant.
Yes.
Her learned counsel, Mr.
Jiuddin.
Jiuddin, for the petitioner. Sujata Basumata, for the petitioner Sujata Basumata, who is apprehending arrest in connection with so-and-so PS Street, who has filed this application under section 482 of the BNWS 2023, as she is apprehending arrest in connection with CIDPS case number so and so under so and so sections. Third, Mr. B. Sharma, learned additional PP Assam. It is submitted on behalf of the petitioner that she is not involved in connection with this case. Full stop. The petitioner has also prayed for anticipatory bail on the ground of parity as a co-accused, namely
Accused namely, my lord, Mrs. Dushila Basumata. Page 18.
Mrs.
Dushila Basumata. 18, my lord. Drushila. Dushila Basumata.
Mrs. Dushila Basumata has been granted anticipatory bail in connection with this case. It is submitted that the petitioner is willing to cooperate with the investigation. Learned additional PP Mr. B. Sharma has raised objections stating that there are incriminating materials in the case diary against the petitioner. Full stop. Money has been transferred to the account of her husband, no? To the account of her husband, which has been procured by blackmailing the informant, Mrs. X, informant X. Who stopped it is also submitted that there are incriminating materials in the case diary against the petitioner, and she is not entitled to anticipatory bail considering the nature of the offense. Full stop. The informant was pushed to the point of committing suicide, and thus the petitioner is not entitled to committing suicide, but somehow the informant, but fortunately the informant did not commit suicide, full stop. Thus the petitioner is not entitled to anticipatory bail. I have considered the submissions at the bar with circumspection. The investigation has been continuing since the year 2015.
15.
Full stop. I have also scrutinized the case diary. I have considered the progress of investigation. It appears that custodial interrogation may not be required. The petitioner has pledged to cooperate with the remaining part of the investigation and to abide by any stringent conditions of bail if imposed upon her. It appears that anticipatory bail may be granted to the petitioner. The petitioner Sujata Basumata, Srimati Sujata Basumata, Basumata's prayer for anticipatory bail is allowed. In the event of the arrest, the petitioner shall be enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition. This will be our cyber
CID.
to the satisfaction of the investigating authority under the condition that the petitioner shall appear before the IO within 10 days and cooperate with the investigation. Number 2, the petitioner shall refrain from such activities with which is alleged. Number 3, the petitioner shall not tamper with the evidence and appear before the IO as and when called for. On breach of any of the bail conditions, the bail order shall automatically stand cancelled. Send back the CD. Okay.
Offline.
Item 16 and 19.
May I please, your lordship? Lordship, item number
16 and 19.
In item number 16, lordship, I am praying for an adjournment. Lordship, may I kindly fix this matter on 25th.
25th. Okay.
25th. TCR is there.
Learned counsel for the petitioner, Mr.
M. Ahmed.
M. Ahmed has prayed for adjournment. Item number 16. List the matter on 24, 25th.
25th.
Okay.
What's this thing? And item number 19. In item number 19, my lord, case diary was called for.
Your Lordship, three petitioners are there. Petitioners were arrested on 31st of March 2026. As on date, the petitioners have completed 49 days. This is a case of intermediate quantity. And Lordship, here I am seeking bail basically on three grounds. The first is this length of detention, that is 49 days. Second is, Lordship, here petitioner number 2 and 3 are female, along with Lordship children. They were arrested in the night. There is clear violation of section 43(5). And to the in this regard, the settled proposition of law is that the arrest is totally illegal. In our High Court, there are judgments whereby the compensation was awarded for such type of arrest. Number 3, Lordship, third ground. Here, Lordship, the petitioners were arrested on 31st of March 2026, and they were produced before the Chief Judicial Magistrate on 2nd of April, that is after 24 hours. These are the three grounds, Lordship, on which I am seeking bail. Now, my Lord, may kindly come to the FIR. Page number 23.
Okay.
First line, I have the honor to inform that on 31/3/2026 at 8:36 p.m. My Lord, may kindly take a note of the date and time.
Yes, yes.
Now, my Lord, may kindly come to the, skip the middle part and come to the second paragraph. We left the police station at about 8:52 p.m. with necessary equipment, including so-and-so, so-and-so. These are so-and-so, so-and-so, so-and-so. At the spot, one person, namely Shamim Mia, that is the petitioner number 1, son of so-and-so of village so-and-so, was found moving in a suspicious manner. Accordingly, the police party apprehended the following person. Number 1, Shamim Mia. Number 2, Manjuara Khatun. Number 3, Mumtaz. This Mumtaz is the wife of the petitioner number 1. Now, my Lord, may kindly come to the next page. The recovery is number 1, 53 numbers of plastic containing 55 grams of suspected heroin. Number 2, 13 numbers of Yava tablet, that is 1.38 grams. So far as the Yava tablet is concerned, Lordship, that is less than small quantity. Small quantity is 2 grams. Now, my Lord, may kindly come to the next paragraph. After completion of all formalities, the police party left the place of occurrence at 12:39 a.m. on 1/4/2026 and reached Mankasur police station at 12:44 a.m. along with the seized item and accused persons. So, my Lord, they were arrested and they were brought to the police station on 1/4/2026 at 12:44 a.m. That is night. Thereafter, the other things are there, Lordship. So, from the FIR, what I am trying to establish is that, Lordship, the petitioners were apprehended on 1/4/2026 and they were brought to the police station at 12:44 a.m. Now, my Lord, coming to the first ground, Lordship, that is 49 days. I'm not going to submit any judgment on that. Now, Lordship, so far as the forwarding of the arrested accused persons after 24 hours, which is a clear violation of section 58, I'm relying on certain judgments. Lordship, may kindly allow me to place those. And before that, Lordship, may kindly come to the forwarding report. Another thing, I just missed it out.
They were produced before the magistrate.
Yes.
Magistrate on
My Lord, may kindly come to page number 25.
25.
25. This is the forwarding report. Page number 26 would be relevant. At the button, date 2/4/2026.
Okay.
Page number 26, yours faithfully, SI Rustam Ali Ahmed of Mankasar PS, date 2/4/2026.
They are showing arrested date and time on 1/4/2026.
My lord, they have written it, this is the date they have written on the forwarding report, but actually they were produced on 2/4. That is the same forwarding report, Lordship.
No. Arrested date and time 1/4/2026, 4:17 PM.
No, Lordship.
They have written.
They have mentioned it,
25.
Lordship, but from the FIR, they were apprehended on 1/4/2026 at 12:44 AM. That is their FIR. From their FIR, I am submitting it. And the judgments, Lordship, which I am relying on, it will cover my submission. Now, my lord, may kindly come to page number 27 for
There at 12:44 PM AM.
AM, Lordship, at night.
1/4.
Now, my lord, may kindly come to page number 27.
Page 27.
27. They were produced, and this is the order passed by the learned Chief Judicial Magistrate on 2/4/2026.
Okay.
And in the prior portion of the forwarding report, they have clearly mentioned that hence the jail authorities may kindly be directed to provide necessary arrangement for them. Manjuara Khatun, daughter age is 3 years, and Mumtaz Khatun, daughter age is 2 years.
Okay.
My lord, may kindly take up the first judgment, that is Directorate of Enforcement versus Subhash Sharma. Even lordship, in the arrest memo also, they have said that the date of arrest is 1st of April, lordship. My lord, may kindly come to paragraph number 4.
But they have shown us forwarding report, they have shown us 4 PM. That is the problem.
No, lordship, but lordship may kindly peruse this judgment. This will make everything clear. Paragraph number 4. In paragraph 10 of the impugned judgment, the High Court has recorded factual finding which reads thus. From the documents available in the case diary and the aforesaid order, it is crystal clear that the applicant was detained and taken into custody at 18 hours, 6 PM on 4/3/2022 at IGI Airport, New Delhi, when the Bureau of Immigration executed the LOC issued against the applicant and held him in custody on behalf of the ED. It is also not in dispute that ED took physical custody. My lord, this is the most important word. Physical custody of the applicant from the Bureau of Immigration at 11 hours, that is 11 AM at so-and-so on 5/3/2022, and brought him to Raipur, where the ED in the afternoon on 6/3/2022 before the remand court. The submission of the learned counsel appearing for the appellant is that pursuant to the lookout circular 4-short LOC issued against the respondent, he was detained at IGI Airport from 11 hours on 5th March, but he was shown as arrested at 1:15 hours on 6 March 2022 by the appellant enforcement director and was produced before the court of the learned magistrate within 24 hours from 1:15 hours on 6th March 2002. This argument cannot be accepted. Admittedly, the LOC was issued at the instance of the appellant directorate of enforcement. By executing the LOC, the Bureau of Immigration detained the respondent at IGI Airport from 4th March on behalf of the appellant. The finding of fact recorded in paragraph number 10 is that undisputedly, the physical custody of the respondent was taken over by the appellant from the Bureau of Immigration at 11 hours on 5th March 2022. Thereafter, at 1:15 hours on 6th March 2022, an arrest memo was prepared by the ED at Raipur. He was produced before the court at 3 p.m. on 6 March. The perusal of the arrest order shows that the typed order was kept ready. The date and time of the arrest were kept blank, which appear to have been filled by hand. Admittedly, the respondent was not produced before the nearest learned judicial magistrate within 24 hours from 11 a.m. on 5th March 2022. Therefore, the arrest of the respondent is rendered completely illegal as a result of the violation of Clause 2 of Article 22 of the Constitution of India. Thus, continuation of the respondent in custody without producing him.
You see, you have to give exclusion of traveling time.
Yes, Lordship, let it be. The exclusion would be, Lordship, it is.
To the CRPC as well as the Constitution.
Yes, Lordship. The place of occurrence and the distance of the court is 20 kilometers.
This is intermediate quantity only.
Intermediate quantity, and
you have to submit such an elaborate argument.
therefore, Lordship, my first submission was length of detention, Lordship. 49 days with 2 children, 2 minor children.
If you have no objection, I'll grant you bail.
Then, Lordship, I am not going to the other part also, Lordship.
You see that exclusion of traveling time is necessary.
Even if, Lordship, we exclude it, then also, Lordship, it will cover my case. And, Lordship,
Yes,
night
any
is also
objection?
there.
I don't think you will have any objection.
That case there in. And as part of my lord, forwarding report, my lord, procedure is already perused, my lord. Date of arrest is 1/4/2026 at 4:15 p.m. Now, my lord, I just take your lordship to my lord, section 46, my lord, of CRPC, my now.
58. 58.
BNSS condition.
BNSS, my lord, is 58.
58.
BNSS. Single is it? Yes. Oh, শকত হ'ব এনেকুৱা এইটো লাষ্টৰ ফালে আছে নি এই লাষ্টৰ তলৰ দুখন শকত দুখন এইখনে
May I place it?
It's okay, we have না ভিতৰত which section?
58, my lord. 58.
No, sir, let me verify. My lord. Will peruse, my lord, 43-1, my.
43-1.
BNSS.
Okay.
My lord, how it is how made, my lord. Then, my lord, may kindly come to my lord 43-5, my lord. 43 subsection 5, my lord. Subclause 5, my lord.
Yes.
There have been exceptional circumstances, no woman shall be arrested after sunset or before sunrise, and there such exceptional circumstances exist. The woman police officer shall, by making a written report, obtain the prior permission of the magistrate or the first class within whose location.
Yes, it is there, exceptional circumstances.
Yes, but this is a case, Manu, where it is the exceptional circumstances, man. Because it is a case, Manu, it is a NDPS case, Manu. It is not, my lord, equal to the other offences, Manu. It is a special act, my lord, and the Manu provision is, my lord, under the act is special, Manu. This is a reports of 37, etc. will come, Manu, although in this.
No, that day I told him, he was
37
submitting, I had told him, I told him.
How, my lord?
In exceptional
When
circumstances.
they were arrested, my lord, that's what a forwarding report, my lord, 1/4/2026, 4:15, 4:17 p.m. my lord. That is evening, my lord. Now, on the next day, my lord, on 2/4/2026, my lord, they were produced, my lord. This is within 24 hours. And regarding them, my lord, if they are arrested at night, my lord, then, my lord, my submission is that, my lord, as per section 46, 43, 5, my lord. The police officer is empowered, my lord. This is a case of under exceptional circumstances.
Yes. But I think I'll grant them bail.
My objection may be recorded.
Yes,
because
yes.
What I submit, my lord, this case is pending to collect the appraisal report. So may I pray, my lord, let the matter come up next Monday, my lord. Till then, my lord.
You have the CD, no?
Yes, CD we have, my lord.
What is the weight? It is intermediate quantity or?
Yes, my lord. It is intermediate quantity, my lord. As per the forwarding report, my lord. This will cover, this 25 gross will fine, my lord.
NDPS এখন দিয়াচোন।
So heroin, my lord, heroin found, my lord, 55 grams, my lord. With oils, my lord. And my lord, 13 numbers of suspected yaba tablets, my lord. With weight is, my lord, 1.38 grams. Admittedly, my lord, it will come under the, my lord, intermediate quantity.
Methamphetamine 50 grams. 1 point, okay, okay.
And secondly, my lord, Courtney may kindly come to FIR, my lord, page number 23. Page number 23 of the page application. If Courtney may kindly come to the second paragraph, my lord. Accordingly, I proceeded to the place of occurrence along with the following police person, my lord. Courtney may kindly see in serial number 6, my lord. Minuara Khatun, my lord. That means, my lord, woman constable was very much present, my lord, while the, my lord, they were arrested. So there is no violation of, my lord, any provision of law, my lord. Only I claim, my lord, let the matter come up on next Monday, my lord. We try to produce the, my lord,
No,
appraisal
no.
report.
This can be granted, I think.
My objection can be recorded.
Two kids are there. Two kids are there. Be
But
granted, I
in spite
think.
of knowing that, my lord, they are involved in this kind of.
True, true.
This is under the NDPS Act.
It's a very heinous offense. That's why minimum sentence is 5 years. Heard learned counsel, Mr. Item number 16, M. Ahmed, for the petitioners, Gurehita Nam likhi diba, 1, 2, 3, who have filed this application under section 483 of the BNWS 2023 with prayer for bail as they are behind bars since 31/3/2026 in connection with so PS case under so sections. Heard Mr. Ajay Borwa, learned additional PP Assam, who has raised serious objections stating that this is a heinous offense. Full stop. The petitioners, the argument of the learned counsel for the petitioners that both the women prisoners or both the women accused are with two children in the jail premises cannot be accepted as they are involved in in a heinous offense, full stop. Both the children are below 3 years and 2 years, full stop. It is further submitted that the it is further submitted, the learned counsel for the petitioners laid stress in his argument that two young kids are with their mothers in the jail premises, full stop. The environment is not suitable for young kids inside the jail. The petitioners have also undergone substantial period of detention, full stop. They have been interrogated thoroughly and further custodial interrogation may not be. Presumably, they have been interrogated thoroughly here. Presumably, they have been interrogated thoroughly and further custodial detention may not be required for the progress of investigation. I have considered the submissions at the bar with circumspection. It appears that further custodial detention may not be required. Most of the petitioners are willing to abide by any stringent bail conditions imposed upon him. I have considered that the petitioners are local residents and are not flight risks. Considering all aspects, both the petitioners, so-and-so, so-and-so, and so-and-so, Tinda, are enlarged on bail of rupees 50,000 each with a suitable surety of like amount to the satisfaction of the learned jurisdictional court, learned jurisdictional court under the condition that the petitioners, number one, shall refrain from such activities with which they are alleged. Number two, the petitioners shall appear before the IO and on every fortnight to completion of investigation. Number three, the petitioners shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, the bail order the court is at liberty to cancel the bail granted to the petitioners. Send back the CD. We have the CD, no?
Highly obliged.
Will send back.
Send back the CD, okay.
Highly obliged.
Item number 39 for hearing.
Well, in this case, I was appointed as amicus curiae. On last occasion, some default on my friend's part, he was not present. He's there in the case now, so
Okay.
it is his baby blood, let you carry on.
Okay, whoever submits, it's up to you.
Let my friend.
Only one thing, Your Lordship, I am not keeping bail today, so let it be on Friday if possible.
This is,
am-
how old is this case? Revision?
20,
2014.
14 better.
Friday is not a hearing date.
That's, I was surprised, today is Monday. Actually, it was listed up.
Oh, because
I am having cold and cough, that's why.
2014, that is.
Yes, sir. Thursday, on Thursday if possible.
Not this week.
28th of May.
Jam-packed week.
28.
Learned Counsel, Mr.
DK Choma.
DK Chomal is present today and is prayed for adjournment. A last adjournment is accorded, list this matter on. Learned amicus curiae, Mr. R. Dubey is also present. Learned additional PP, Mr. KK Parashar is present. List this matter for hearing on. Aru ase niki na? Sorry.
গরম গরম ভাবলি
Like,